Like, I have not always been a victim, but like right now I'm a freaking victim in the situation.
He and the defendant, Clenney, had been involved in an extremely tempestuous and combative relationship.
Don't touch me!
What is going on?
He had my neck, and this happened twice before, where I couldn't breathe.
I was sober for 2 weeks. 2 weeks, 2 weeks. And now why am I not sober? Because of you.
In our spotlight this morning, the case against former OnlyFans model Courtney Clenney is delayed yet again. And we're talking to her attorneys about it all this morning. So Clenney is accused of murdering her boyfriend, Christian Obumseli, during an argument that the couple had inside of their Miami condo back in 2022. Clenney claims that she threw a knife at Obumseli in self-defense. She was arrested more than 3 years ago and has been held without any bond ever since. Here's her attorney, Frank Prieto, in court last week talking about the delays.
We need to get this moving. Again, Ms. Clenney's been in custody now 3 years and 2 months. It's time to get this in a realistic trial date position.
Prosecutors rejected claims that the state is drawing out the case, telling the court that the defense filed the motions to suppress evidence and reconsider her bond and dismiss the case, and that they had to deal with those. Now, the hearing to reconsider bond is now set for November the 4th, and the December 1st trial date has been postponed. The judge set a December 5th deadline to respond to the attorney's filings. No trial date is on the calendar at this point. So let's bring in Courtney Clenney's attorneys, Frank Prieto and Sabrina Puglisi. Good morning to you both. Thanks for coming back on the show. All right, so let's talk about where things stand now. Let's talk about the trial first, and then we're going to get to the bond. So many of our viewers, I'm sure you both can believe it, ask often, when's this case happening? When's it going? And I know I've asked you both often when you've been on the show, and unfortunately, we just haven't had a date. Sabrina, realistically, when do you think this is going to go?
Realistically, we're hoping for the first part of next year. Due to scheduling and all the motions, all the delays, Julie, that we've had. And much of it has been because of the prosecutorial misconduct with the breach of privilege. But we finally are past that. We're now getting ready to really go to the meat of the case, which is getting ready to litigate the motions. And then as soon as those are done, we'll be ready for trial. So yeah, realistically, I think we're going to be looking at the first part of next year, sometime in first quarter.
Okay, so wintertime, somewhere in there. I know you both have been preparing for a long time. We've talked a lot about the case. Frank, I want to turn to you about the bond. We saw you in court making those arguments. We know now the bond hearing coming up sooner than any trial, November 4th. We have a clip from what the prosecuting attorney, Sean Abuhoff, had to say, I might be mispronouncing that name, had to say about your client possibly getting bond. Let's take a listen.
Are you going to respond in writing to the reconsideration of the bond?
So, Judge, that's the hard part about this, is that there's not much that's new within this. There are, they're asking for reconsideration based off of the amount of time and the litigation that took place really over the last 18 months. It doesn't change the risk of flight, the dangerousness. It doesn't, I honestly don't believe that there's any form of evidentiary hearing that will be necessary. And it's one of those that certainly if Your Honor believes I should respond, I'm happy to. But I don't believe there are grounds in this to warrant the defendant's release.
All right, Counselor Prieto, what's your response to that, please?
Julie, thanks for having us again. But so listen, the prosecutor, he raises a fair point. He's indicating that, saying that, hey, look, Judge, there's nothing new here. There's no new evidence. And so that the court should deny it. And Judge Wolfson is going to consider his argument. She indicated she's not sitting in an appellate capacity to overturn Judge Cruz's decision. But we did raise new issues. And one of the issues, it's connected to our motion to dismiss. We found out in a collateral proceeding that a witness, the first person to enter Miss Clenney's apartment, was videotaping on his phone and taking pictures. And after the police were interviewing him, they instructed him to delete all his videos and all the photos, which was the pristine alleged crime scene. So this is new evidence that I think the court needs to consider, that this would have been helpful for the defense. It raises issues of the preservation of the crime scene. And I think that it's something the judge should consider, along with the previous misconduct on the part of the government, to say, hey, look, there is new evidence here. I can reconsider bond. And hopefully Courtney will be out while we prepare for her trial.
Whoa. Okay, Frank, we want to back the truck up with you. Back the truck. I am horrified. So I guess first question, was whatever was deleted recoverable?
According to that civilian witness, he deleted everything at the direction of the police. And then that was approximately, and then he changed his phone. Look, the government should have been aware of this, because the video that they turned over, surveillance video the government turned over to us from the elevator, shows this individual on his phone clearly filming. The government should have, they were in a better position when they had this before they even filed the case. They should have preserved that. They should have interviewed this gentleman. They should have served, iCloud warrants, whatnot on his phone. And it turns out he was never even interviewed by the state attorneys in this case. In fact, the lead detective never interviewed this guy. It was apparently a patrol officer who stood over him, according to his testimony, and made him delete all the video and audio. Now, what was on there, we don't know. Obviously, the camera wasn't there when the event took place, when Miss Clenney was defending herself. But this is what we call a Youngblood violation. Destruction of evidence, and that's the basis for the motion to dismiss, which ties into our reason to ask for another bond.
Wow. I mean, I can't say I'm surprised. I mean, these things unfortunately happen. Good on both of you discovering that and being able to raise it as a viable issue for your client. And I would think, and I'm certainly not trying to speak for anybody or put words in anyone's mouth, but I would think the Albumselli family would probably be disgusted as well, because if there was something, like you said, Frank, you don't know what's on there that they may want to see. Obviously they're very upset and coming from a different perspective than you both are. You're advocates for Courtney. I can't believe a police officer would tell a witness to get rid of potential evidence. Can you share with me, was this a neighbor? Can you give us a little bit of an idea of who this gentleman was, if you know?
Yeah, Julie. Yeah, and listen, it is shocking. It's completely shocking to hear that whether it's a patrol officer or a detective, they're destroying evidence, right? It's crazy, but this case has taken a turn for somewhat. There are so many issues that have come up in this case. You're well aware of the misconduct, the reading of our attorney-client privileged communications. It's absolutely crazy. It's bizarre, and it's a sad statement of how the justice system can work sometimes. But this gentleman was one of the employees of the condominium.
Oh, wow.
So he was there first with the security guard filming, which would have, revealed what was occurring at that point. It was minutes before the cops got there, the police officers. So.
Yeah, exactly. He was there before them. Boy, that's really unfortunate. But that's a really interesting issue, even if it doesn't support your position at the bond hearing, perhaps at trial. It's obviously you two are such pros. You'll explore that on your crosses. Sabrina, let me go back to you, please. We know that you all have filed motions to exclude many of the phone recordings. Courtney and Christian recorded each other, a lot of toxicity, as we know. The phone calls that he recorded that are very damaging to her, where does that stand?
We have that pending. What we had to do was to supplement just the exact recordings, and we've done that. We refiled that, and so that will be pending. I mean, the case law is really clear that surreptitious recordings should not be admitted into evidence. And honestly, when you think about it, this is the whole thing of what Christian used to do, right? He used to taunt her. He used to gaslight her, get her to a point, and then he would record her. We don't know anything of what occurred before those recordings started. And that's why not only is it illegal to record somebody without their permission, it also is very unfair because it doesn't portray exactly what occurred during the situations.
Yeah, tough case. This is, I've said it before, I'll say it again. The best thing going for Courtney Clenney are the two of you, Sabrina Puglisi, Frank Prieto, excellent advocates you both are. And with this new information, we're going to have to reach out to the Abumseli family. Perhaps Attorney Mike Haggard, maybe he'll speak with us and see if they would. I would be upset if I were them, and this is potential evidence that's been destroyed for no good reason. Thank you both for the new information. We'll see you soon, I hope.